All right, welcome back, everyone. We are back in session, and next up on the docket, we have case 22-2813, Morningstar Assisted Living versus SafePoint Insurance Company. And how much time did you want for a vote?
I'll take 5 minutes for
5 minutes? All right. And we're going to have 20 minutes aside, just so
Thank you.
it's a little bit of a different situation than the last case, so.
Good morning, Your Honor. May it please the court. I'm Brandon Vesely from the Florida Appellate Firm. I'm here on behalf of Morningstar Assisted Living, LLC, which was a assisted living facility. This case, let's talk about the undisputed facts. This case is a first-party insurance case. There was a policy with SafePoint Insurance Company, the appellee, and that's policy number SPCP0001344. It was for business personal property. It wasn't for the building itself. It was just for business personal property. The insured was Morningstar, my client. This case involved a fire that occurred on the premises. Fire was in the laundry room at the facility. Several pieces of equipment got destroyed in the fire. There's no dispute about any of that. So my client, let's see, that happened in September of 2020, and my client in May of 2021 filed a claim, less than $15,000, asking for payment for some of the equipment that they lost under their business personal property insurance policy. SafePoint responded and took 2 examinations under oath, made my client place 2 claims, and those examinations under oath determined that the property was actually owned by another entity. But this isn't like an insurance fraud case, Your Honor. This is a case where my client and her company, Morning Dew, who also is the shareholder, the main shareholder of Morningstar, bought the premises under Morning Dew, started her business, Morningstar, and it was kind of a question whether the property, the personal property inside, was part of the business before or after. But as the case proceeded and they did these examinations under oath, my client testified that those pieces of equipment that we're claiming were actually in the premises when Morning Dew bought it. So everybody understands then, well, Morning Dew probably owns it. Even though we're leasing the premises from Morning Dew, Morningstar is leasing it, Morning Dew probably owns it. So we go through, litigation all the way up to 2022 when SafePoint files their answer to the complaint, and they deny the claim. Okay, we're already litigating for a year. They deny the claim, and they say, over a year, and they say, you don't own it. And then they file a motion for summary judgment and says, you don't own the property, you can't bring this claim. You have no standing. That's the word, no standing. So they file this motion for summary judgment, and counsel for the appellant, Morningstar, files a motion to amend and says, okay, let's bring a motion to amend. We'll bring in the owners. So they're all related companies. We'll bring them in, and we'll proceed on that. Well, the policy itself has a provision, 2 provisions actually, that allow Morningstar, the insured, to bring a claim on behalf of other people's property, personal property of others that's on their location. They're the insured. This is a business personal property insurance policy. If there's property on the premises that belong to somebody else, they can put a claim in for that on behalf of those other parties.
I understand the argument, counsel, but what do you do with the language of the rule? At least 20 days before the time fixed for the hearing, the non-movement movant, that would be your client, must serve a response. And no response was served here. So even though that was a credible argument, no response was ever served. Does that matter?
Your Honor, the response is the motion to amend, which is what we filed to bring in these parties.
That's a completely different issue, but you're saying now, what I just heard you say, I thought, but please correct me if I'm wrong, is the policy would allow the very thing that happened. Meaning the client that was a plaintiff, your client that was a plaintiff in this case, had the right on behalf of someone else to bring an insurance claim. Didn't you just say that based on the policy?
Yes, Your Honor.
But that sounds like a response to the motion for summary judgment as opposed to a motion to amend, but maybe I'm missing something.
They were kind of mixed together, but the point is, in order to bring the motion to amend, to bring in those other parties, that you have to bring the claim on behalf of. Okay, so they were named as parties in the motion to amend. But Your Honor, I understand that the rule specifically says you have to file a response. No question, our side did not do that. But the documents that we would have appended to a response were actually part of the record filed by the movant when they filed the policy. The policy is what governs this. And the policy is the only thing that we needed. They already filed the two examinations under oath of my client. Not my client, Constant Powell, who was the person who testified under oath in the examination. They filed both of those. I don't know what we would have filed that would have been any different other than just repetitive things, Your Honor. So I'm not saying that's an excuse or gets us out of a requirement to file, but what else would we have filed because there wasn't anything else to file?
What do you make of the word, and words matter, I know you know they matter, must. What does must mean to you in the context of this rule?
Your Honor,
That's the language of the rule, correct?
I'm not disputing that the rule says that. What would we have filed differently? There isn't anything else to file. I guess we could have filed an affidavit, but it would have said the same thing that her deposition testimony, her examination under oath testimony said. So I'm not, and we actually argued a response. Now, trial counsel didn't file anything with in response, but he argued a response, and he said, under the policy, we also have a claim for loss of use. And that was argued at the hearing, and nobody objected and said he couldn't make that argument, but that was argued at the hearing, and I'm more focused, and I was leading up to it, on the motion to amend. And that's really where I think this case turns for us, because we had a motion to amend pending. It wasn't untimely. It was denied as untimely, and it wasn't untimely.
Well, counsel, the motion to amend was denied, as you mentioned, but you didn't appeal that denial, did you? You appealed the rehearing, the denial of the rehearing on that motion, is that correct?
No, we appealed the denial of the, I'm not sure what you're saying. We appealed
the order that denied the motion to amend.
Right, which was part of the final, which also part of the final judgment, which was subsequently entered. So there was an order granting a motion for summary judgment, and then there was a order denying the motion to amend, both of which were part of the final judgment, which we appealed. And as you know, Your Honor, every order that pre-exists the final judgment is included in being appealed by, can be appealed by appealing the final judgment. Everything, all orders prior to that. Okay. So,
Is the standard on the motion to amend abuse of discretion?
it is, Your Honor, but you have to look at what the judge found. And the judge found that we were untimely. The judge was angry. I shouldn't say angry. From his words, it sounds like he was upset about the fact that we waited so long to bring this motion to amend. However, if you look at what happened, we didn't wait a long time. We were very close in time to the time that they filed their answer. We were very close in time to the time that they filed their motion for summary judgment. And we were well before the hearing on the summary judgment, and there was never a trial set. It was our first motion to amend, Your Honor.
Help me understand procedurally. I have not gone back through the trial court document. Why a late answer in this case? Was there a pending motion to dismiss?
There was, Your Honor.
So that was ultimately denied?
Yes, and then it took some time after that to and that was determined late. And it took some time after that to actually have the answer filed. And then so the answer was filed in a couple months later, a month and a half later, they filed their motion for summary judgment. And then within 6 weeks, we filed our motion to amend. And then 3 weeks later, the motion for summary judgment and the motion to amend were heard on the same day. And then after that, there was never a trial set in this case, ever. So, I mean, we're talking about a first motion to amend, to bring in the parties, to bring a claim that is clearly available under this policy. So let's talk about what they needed to prove on their motion to amend. Well, the only grounds for denying a motion to amend really are prejudice to the other side, and they never even mentioned it at trial until the judge said, well, your prejudice is time and expense. But that would be prejudice.
The basis of the court's ruling here was prejudice. Right, prejudice to the other side.
Well, it's timeliness is the basis of the rule.
Well, I understand that, but there are separate buckets, and I think everyone agrees this was not futile, correct?
I mean, I don't see how it can be futile when the policy says on page 2.
Right, and so I think that's accepted, but the court never talked about futility in its decision, correct?
That's right.
So it sounds like it comes down to whether this amendment prejudiced the other side, and as part of that, I guess the court was saying that it did prejudice the other side because you didn't do it soon enough. I mean, is that your takeaway for why the court did what it did?
Exactly, and there was no evidence of that. There was no evidence of prejudice. There was no evidence that they didn't. The judge threw it out there at the very end as a softball and says, "Hey, you know, you're saying there's prejudice because of your time and expense." Yes, that's it. So I mean, prejudice would be every case where there's a motion to amend if time and expense was the factor.
So I can understand this case was not set for trial.
No.
And this was the first motion to amend.
Absolutely.
Is there a case out there where an appellate court has affirmed a denial of a motion to amend?
Well, you know,
the first motion to amend when the case is not set for trial?
Your Honor, you never know. PCAs are out there, I don't know.
Well, PCAs,
but I've never seen a case, in the cases that I cited, there's a plethora of cases that say you cannot deny a motion to amend unless you can prove real prejudice, or unless you can prove that the amendment would be futile, or unless you can prove that the privilege to amend was abused. And the cases are legion. There's 30 of them, at least, that say it's an abuse of discretion, particularly in the context of a motion for summary judgment. In the context where this is what happens. People move for summary judgment or they answer a complaint, and you see the errors, the flaws of your complaint, and then you try to fix them. And then the case is determined on its merits, rather than being determined on a gotcha, which is what this case is. You never pled it right, gotcha. Okay, my client, I mean, it's an honest mistake. They didn't realize that the owner of the property, that the property existed in the building at the time the building was bought. So they didn't know. And once they figured it out, within a short period of time, they moved to amend and claim it for the right parties. So, and the policy does provide that. So this is like, now we're 4 years in the litigation on a $15,000 claim. That's all we're talking about, less than $15,000. 4 years in the litigation on this. And, I mean, why is the onus not on the insurance company to go, you know what, they're not the owner, but you do have coverage for that. Here's your coverage. Put your claim in correctly and we'll pay you the $15,000. Instead of playing gotcha. These are their premium paying clients that are diligent in paying their premium every month. I'm generically, I'm speaking.
Was there not a separate case that involved the other party that when you filed a motion to amend that would include these additional parties, weren't the additional parties, at least one of them, involved in another claim because they had their own separate policy? Morning Dew and Constant Powell had property insurance. Not business property, had property insurance, and they brought a claim for that. It's not even in the record, Your Honor. I mean, they talked about it, but there's no judicial notice of it. There's nothing in the record to even say that. But the point is, you can look it up yourself. It's a property claim. It did not cover what we covered in the business purpose personal property insurance, which is a separate policy.
SafePoint wouldn't sell the same policy twice. If they didn't need business personal property, then they wouldn't have bought business personal property. But instead, SafePoint has this business personal property insurance policy for Morningstar, and Morningstar has a loss. Morningstar, as the insured, has a loss. They can't use that dryer anymore. Oh, you find out Morning Dew owns the dryer. Okay, well, the policy covers that. Why should they not get paid for that? This is where we're at, Your Honor. So I just find it incredulous that an insurance company would play this game, take multiple examinations under oath and everything, and figure out, okay, it's not them, but it's this person that owns it over here. Okay, we're going to deny the claim, and we're going to go through litigation for years on this, or maybe they think they're not going to bring it.
Examinations under oath occur before or after the suit is filed.
Before.
So the determination, the testimony with respect to who owned the property was taken before the suit was filed, and then the suit was filed in a different name?
No, I might be wrong on that. Let me check into that. Okay, the first examination under oath. Sorry, Your Honor, it'll take me a second to find. You know what?
You're about a minute into your rebuttal. It's okay.
I'll look in the break.
No
Okay,
worries.
I appreciate that very much. Your Honor, we also have a claim for attorney's fees, obviously, because this is one of those first-party cases. Your Honor, we're asking the court to reverse this, allow us to go back and have a trial on the merits. Okay, that's what these cases say. These motions to amend are to allow the parties to have a trial on the merits, not play these gotcha games. And we'd ask the court to reverse it to allow us to do that. Obviously, the policy covers it. Obviously, we have the right parties involved now on the motion to amend. And obviously, we ought to be able to bring our case and present it to hopefully succeed.
Thank you.
Good morning. Patrick Williams for the Appalachia SafePoint Insurance Company. Setting aside the issues that are raised for the first time in the initial brief, this appeal challenges essentially two things that were heard, reheard, reconsidered through multiple hearings, multiple briefs in front of the trial court. There were some errors in the argument before and some of the facts that were raised, particularly as to the amendment issue that I want to address. I want to start with the sort of the sequence of the investigation because I think Judge Kilbane, you hit on something there in the initial claim investigation. So this claim was reported to my client through counsel, 2 sworn proofs of loss. Both say that Morningstar owns this property. There are then 3 EOs, 2 of Morningstar's corporate representative. And during those EOs, Morningstar is actually represented by counsel who will file the complaint. So they are aware of these facts well before they actually file a lawsuit. Lawsuit's filed. Paragraph 2 of the complaint says Morningstar is the owner of this property. Consistent with sworn proofs of loss, my client at that point had not yet denied the claim. It's still being investigated. So my client proceeds through the case for a year, litigating the theory that Morningstar owns this property. We get to summary judgment, and this is 100 days after fact discovery, and I believe 200 days after the deadline to add parties. At this point, we moved for summary judgment on the grounds that you sued us, you brought a claim as the owner of this property. You moved for summary judgment on that, and you don't own the property. And you knew that before you filed this lawsuit, that the lawyer was there at that EUO where they said, contrary to the sworn proofs of loss, which to this date have not been amended, there's still been no claim by either of these other 2 parties.
And thank you for the background. The background is very helpful. Is there a case, an appellate case in the state of Florida, where a case is not set for trial, and it's the First Amendment which is denied, and that's affirmed on appeal?
Judge, let me clarify that because the characterization of this is a motion to amend, and I'll answer this question directly. The case law cited in their briefing involves an amendment by a party to its existing claim. In other words, I've sued for negligence, and I'm also now going to sue you for a different kind of negligence in the same action. None of the cases they've cited involve an amendment that doesn't change the movement's claim and attempts to add 2 brand new parties at this point in the case. So why is that important? Well, there was another argument that that was raised on futility, that I believe counsel said there was no argument on futility. That's incorrect. In response to the motion for reconsideration, SafePoint pointed out that the proposed amended complaint as to Morningstar brought exactly the same claim that we were entitled to summary judgment on. So even if you grant the amendment, the claim that Morningstar brought, that Morningstar has appealed, is still entitled to summary judgment. It still says owner. It doesn't say third-party property. It doesn't say loss of use. What it wanted to do was bring in two entirely new parties. And these parties have different owners. They're entirely different people. They have their own lawsuit against my client pending while all this is happening.
But it sounds like that was a different type of coverage. Do you disagree with that?
Your Honor, honestly, I don't know the answer to that. The reason is there may be coverage in those policies that might have overlapped with coverage here. That's really important because we're a year into this case. My client litigated the lawsuit brought against it, just the claim brought against it. Now they want to add two entirely new plaintiffs who, by the way, haven't appealed. And those people are saying, no, we own the property. That's a new lawsuit. That's not, so as to your question, an amendment, if I'm recharacterizing the facts that the parties have litigated, I would agree with you. I would say that amendment should be granted, especially on the first one. Now we're late in the game, but we weren't set to trial.
So you would agree with what I asked Kim, that it was all about one party moving to amend as to that party. That's I don't want to use the word I'm thinking of, but that's an easy decision.
Yeah,
You're saying this is different than that because there's the addition of two new parties.
Yes, Your Honor, two new parties with entirely inconsistent.
And those parties are not part of this appeal.
They have not appealed. And Your Honor, I looked around the country for this and found two cases, because it's pretty rare that happens. You're precluded from participating and you choose not to appeal. It's the Thomas case and the Michella case. They're federal courts.
Do you have the cites on those?
Sure. Let me find it. Thomas is 631 Federal 3rd, 1153. That's the 10th Circuit. And Michella, which it relies on, is 653 Federal 2nd, 923. That's the 5th Circuit. So those cases they're federal cases. I understand that jurisdictional issue, but the standard in federal court is if a party is aggrieved. The standard from the Florida Supreme Court in Raymart is if a party has been adversely affected by a decision. It's the same standard, but in the Thomas case, what the plaintiff tried to do was amend to add plaintiffs with security fraud case, the claims that the plaintiffs didn't have. Plaintiffs appeal, non-plaintiffs don't appeal. Federal court says you're not aggrieved. What you're trying to do is protect the rights of a third party, and you don't have the ability to do that. So they dismiss on jurisdiction on the claim, on the theory, that those two parties, in this case, that weren't allowed to appeal, they didn't choose to appeal. The two parties that were aggrieved by this order, the denial of the amendment, are not before the court. And frankly, if this court were to reverse, I think the denial of the amendment as to them still remains final. They didn't seek rehearing, they didn't seek reconsideration. They never wanted to participate in this appeal. The claims that Morningstar brought in the initial complaint and the proposed amended complaint are identical. So at the summary judgment point, they didn't file a response. The pleading is binding, and my client's statement of facts is uncontradicted. I don't think there's any basis for them to say that this is an amendment of their claim. It's not. There's nothing different about their claim. That's why the first argument we made.
So back to what you said earlier, counsel, this would be, based on your client's position, SafePoint's position, futile. It would just be, basically it would not gain anything beyond what had been previously pleaded, correct?
Absolutely, Your Honor. And this isn't like some, I know the appellant's trying to conflate these three entities like they're the same thing, but this is important. If these two new parties are allowed to now become new plaintiffs, this case is restarting. And it's not just restarting. Now there are new, really important defenses like the other insurance laws that would apply. You need to do discovery, figure out, is this stuff really in their care, custody, control? Who's paying taxes on it? Who's using it? How are they using it? Is it these? These are all questions that would reopen discovery. And I'm sure that with former circuit court judges and people who had to deal with similar deadlines, the trial court was expected to push this case along and to adjudicate the case that was in front of it. My client did what it should in that situation. It adjudicated the claim against it. This is not a motion to amend that's intended to clarify like a legal defect, or somebody brings negligence and there's a contract. They want to call it an outreach of contract. Their claim was consistent from day one. It was consistent with their sworn proofs of loss, and it was wrong. And instead, they trying to change their claim, they wanted to add two new parties who chose not to appeal that issue in front of this court.
The question I asked early in the appellant's argument about the rule of procedure, is that a feature of all this? The fact that there was no response filed in contradiction, opposition to the motion for summary judgment, and the rule says must. Is that a feature of our analysis?
Certainly. I mean, it renders the amendment futile as to Morningstar because that ruling is intact. And that would not have changed. That ruling, once you accept our factual statement, which is they don't own the property, they have alleged to own the property, and they're suing us for breach. That's paragraphs 2 and 37 of the complaint. They're not paying the sworn proof of loss that says they're the owner, and they're not. So that breach claim is dead, based on our statement of facts, which is uncontradicted. And I want to emphasize that this was not a mistake. It was a tactical decision. At record 1454 in the hearing on reconsideration of the hearing, their counsel says, we looked at that, your argument, technically that was right. And so what we decided to do instead of responding or filing an affidavit is to move to amend to add these parties. So it wasn't like, in my mind, that's conceding the summary judgment argument entirely. Their solution was to add parties that have an entirely different lawsuit. 100 days after fact discovery, 200 days after the deadline for new parties to join. And I don't think there was anything wrong with the trial court at that point saying, this is a new lawsuit. And we did raise a futility argument in our papers when they moved for reconsideration. We moved for rehearing in front of a successor judge. There's another hearing, and they asked for leave to file additional briefing, which the trial court then grants again. So these issues were fleshed out completely. And I think the trial court had the right or had the obligation to push this case along consistent with the deadlines. My client had the right to adjudicate this claim brought against it. And as we said in the trial court, these two new parties never made a claim for this. They never submitted a claim, we didn't adjust a claim. They can submit a claim. And frankly, Morningstar never submitted a claim consistent with most of its appellate arguments. So I think that the language must, at least my understanding of the rules, must serve the supporting factual statement 20 days before the hearing. There is no supporting factual statement submitted by Morningstar, and as I said, the record of 1454 confirms to me that that was a tactical decision. They chose, all right, you're right, they're out, these new people are in. These new people are at the exact same time are litigating a much bigger claim against my client from the same laws. So I don't know who represented them with respect to the amendment in this case, or who should have appealed, or how that should have worked out. But they did not choose to either seek rehearing or appeal from the order that precluded them from participating. And that's the Thomas and the Michello cases point out that if you're trying to protect the rights of a third party who doesn't want to appeal, this is a matter of jurisdiction. This is not tipsy coachman, this is actual appellate jurisdiction, the court's ability to grant relief from an inferior court order. So I do agree with your view of the summary judgment ruling. I'll touch briefly on the actual merits of the summary judgment argument. I just want to emphasize that these arguments about the property being this being somebody else's personal property is directly contrary to their plea, and it is crystal clear. Paragraph 2 of the original and amended complaint say that Morningstar owns this property. That's how they chose to sue us, and I think it's our right to defend that claim against us, which is exactly what we did. And not only is it inconsistent with the pleadings, it's also inconsistent with the information we received before the case. There's sworn proof of loss, and I'm sure the court knows that sworn proof of loss is the starting point of an insurance investigation. It's where we gather the initial information. We've got not one but two, both stating that the only person with any interest in the property other than Morningstar was Fidelity Bank and Florida First Capital. No mention of any other party. And even after all this came out, they still haven't amended that proof of loss. So there's no claim, and this notion that my client should have reached a different conclusion. We are reaching a conclusion based on the information provided to us, and then defending a lawsuit based on what was alleged against us. And I don't know of a world where the trial court can be faulted for adjudicating the case that was then pending in the lawsuit. I'll leave with the point again that I think the trial court properly looked at the claims before, properly adjudicated this case consistent with the deadlines that the trial court imposed. And I think that for that reason, I don't believe the trial court abused its discretion. Certainly the summary judgment ruling, I think today has been confirmed, should be affirmed in any event. I think that also renders the any claim of amendment futile as to Morningstar. The other parties haven't appealed. This court should affirm the trial court. Was there any other questions? Thank you.
Thank you very much.
3 minutes, I'll be brief, Your Honors. So, Morning Dew and Constance Powell were not parties to the case. They didn't move to intervene themselves. This was Morningstar trying to bring in other parties. So the proper party to bring, and Morningstar was the insured under the policy and would have been bringing the claim through them on their behalf. So I think they're the only party that was proper to bring this appeal. I don't think two parties that were not didn't even move to intervene have any standing to bring an appeal. So they were not named as appellants in this appeal. And they're not appellees because they were never in the case. They never were part of the case. So they can't appeal.
Well, counsel, what's your position with respect to whether or not the amendment still stated that Morningstar was the owner of the property?
That's not correct, Your Honor. And I put it in my reply brief. There's a couple provisions where they say they admitted. They do say that they were the insured. They are the insured. There was one time I think in there it might have said that they had some ownership interest, but you have to remember they also have a claim for they have a claim for loss of use. So, it's contradictory, but there are at least two provisions in there that recognize, in the amended complaint, are different, that recognize that Morning Dew and Powell are the owners of the property, based on all of this that came out in the examination under oath. And Morningstar is the insured. So, for counsel to say that Morning Dew and Powell have, a separate claim. They can't bring a claim under this policy. They're not the insured. There's no question about that. Morningstar has to be the claimant under this policy. Well, this policy is worthless. If they don't own any property, then it's worthless. But they can bring a claim on behalf of the owner of the property. It's on page 2. We're not talking about, some provision that's buried. It's on page 2 of the contract. It says that. I've quoted it probably 5 times in my briefs. And we're not, he talks about this will be so tragic we'd have to reopen discovery. You have to remember, they filed their answer on February 14, 2022. We filed a motion for summary judgment, our motion to amend on April of 2022, April 29th of 2022, 2 months later. So we're in the even though this case had gone off a while because of the motion to dismiss, we're in the early stages. It's still a beginning case. This is we filed our complaint, they filed their answer, we get to, we try to amend our complaint based on what they put in their answer and based on their motion for summary judgment. I've seen cases where there's 4 or 5 times amendments. This is early in the case. This is, let's try this case on the merits. Let's allow us to get back into court so Morningstar, the insured, can bring their claim on behalf of Morning Dew and Powell for the property that is the subject of the contract for which they paid premiums for years. That's what I'm asking the court to do. And also the grant our attorney's fees. Thank you very much, Your Honor.
Thank you. All right. Well, with that concludes today's arguments.